Judge may approach. Or I
Yes.
guess may we approach?
Yes.
So on this pretrial violation, I was looking over it and it says the positive test was on November 15th, 2025, which is in the future.
Yes.
Well,
Well, sometimes we look to the future as opposed to past.
Yeah,
I think this
Yeah,
test
they do that.
is a clairvoyant.
because they even put it on there right
So
there.
I'm not sure how to, I mean, I would need a clarification on the positive date before.
Yeah.
That's why I handed over to you all. Well,
Well,
if
she
you all,
found it, I didn't. I'm like, I'm already in beg mode. and-
all right, if you all want to, because I do have to address the violation
Yeah.
report, I can email the pretrial officer
Yeah,
and
Just to confirm the
Yeah.
date and then we can make our
Yeah.
decision.
because all of
I-
these,
and
they
for
want
the
you to address and
Judge,
put
I
it in the
have
system.
not had any contact with her, so I don't know,
Okay. All righty.
Thank you, Judge.
Sure. You know what I can do? I'll just have Norma set it for a hearing, so
Yeah.
you'll get contact because they'll come in.
Yeah,
Okay.
okay, thank, that's good.
You're welcome. All right, so where are we on this case with discovery?
First sitting, Judge, I'm still reviewing it. I will let you know, I've received some medical records, from the family. My client's been found incompetent before, so I need to do a motion to make sure he's evaluated for this case.
Okay. All right, when are you gonna have the motion, Paul?
I'll do it today.
All right. All right, Ms. Ferguson. I need this case recalled at the beginning of December. All right, we'll see you back on December 2nd. Once you sign the reset form, you're excused. Thank you for dressing appropriately for court. All right, just have a seat. Your attorney will bring the reset form to you. You're welcome. It's discovery.
Why all the hate on your coach?
No, here's the thing. You know,
I
I
just
just,
follow everything.
let me just tell you, I have love in my heart for all. However, why would you bring the coach from Notre Dame? What did he do with Notre Dame? And here's one of my pet peeves. Really, defense, you're supposed to be playing your position, right? And when the coaches tell you, this is your position, play your position, if somebody catches a pass outside of your position, that's not on you because you're playing your position. Now, if you don't play your position and you're not disciplined to play your position and you go over here, that's your fault. But if you would look at the positioning of the defensive players, like if the quarterback was running right, you have all these offensive players over here. What is the defense? Everybody on the defense is running right. And then the pass gets thrown, which they always tell a quarterback never throw across your body, right? But some do.
They all do.
And they catch that ball, and then guess what ends up happening? Then you get a touchdown. But how are you going to be a coach? Your tackling is not good. And I don't blame players because that's all coaching. And then now you have to pay them his huge package. And then now you're talking about Lane Kiffin. That's what the whispers are. I mean, you might as well come and pick me. I would do a better job because you know why? I know what I don't know, and I would get great people in place.
It's actually a sign of a great leader. Seriously, it's usually the ones that think that they know everything and don't need help.
I don't know. Hello, hi.
Thanks, Judge.
All right, how's it going? All right, have a good one. All right, you're here on a motion to reconsider sentence.
That's correct, Your Honor. The court
Yeah.
may recall a few weeks ago, he was here on a revocation proceeding. He pled true. There was an agreement with the state for a recommended sentence on his revocation of 6 months in the state jail facility.
Mhm.
Obviously, that's not binding on the court, and the court's view of the circumstances at the time was such that I think the court assessed a 14-month sentence, if I'm not
Yes.
mistaken. You may recall, Your Honor, that the defendant's father was here and provided testimony about his mental health issues and some of the circumstances regarding the underlying offense. It's an unauthorized use of a motor vehicle, which involved his parents' car. In talking to the parents, it's not something they were excited about pursuing. but we didn't represent him on the underlying charge, so here we are. The situation arose that after the father's testimony, I think the court was inclined to reconsider if there was some documentation that would have supported or maybe corroborate the mental health circumstances that he had been encountering in his life. And also, I think there was submission at the time from probation that he had not accomplished anything while he was on probation. What we have tendered to the court for purposes of reconsideration are medical records we were able to obtain from the University Health System. You may recall his parents had him involuntarily committed at one point. These records we've obtained kind of, I think, demonstrate to the court some of what Mr. Green has been dealing with. On page 2 of the records, I think of the medical records, page 1 is just the cover sheet they sent us, but page 2 has an assessment per EMR of bipolar 1 manic with psychotic features. The other pages we have selected for the court's review kind of corroborate that, go into a little more detail about his bipolar. And really what happened, I think, in history was his circumstances domestically were kind of on the downside. His wife left him. She took the kids. He went into a pretty deep state of depression and precipitated all this stuff. He ended up losing his job, living on the street, picking up shoplifting cases, and here we are. But to his credit, he didn't just completely go off the deep end. He got involved in a church, a ministry here. We have included as an attachment to today's motion, a letter from the pastor of that ministry, a Blaze ministry here in San Antonio. And she corroborates that he had been very, very active in that church once he joined it. He, not just in the ministry program on a volunteer basis, but he also helped a lot just in the physical plant, the maintenance, just the heavy lifting and toting that is associated with maintaining a property. And so I think his heart has been in the right place. His mind has been anywhere but where it should be. And under the circumstances, his father and mother would love for him at some point when this is behind him to relocate to where they're at in Texarkana. They will provide a home for him, get him back on his feet. He's got a job prospect there that is very promising. And his biggest concern right now is being able to resume some type of productive life, be able to pay child support to his children, and kind of renew and reconstruct his life with his children. And with those things in mind, we're hoping that the court would reconsider the agreed recommendation from the state. It obviously, the court's judgment is what we abide by, and we live with that, and we're grateful for your reconsideration of this matter. But the recommendation from the state wasn't haphazardly arrived at. I think we discussed his whole situation, the underlying offense, the circumstances of his living at the time, mental issues. And so we felt like it was appropriate. And we're hoping the court would reconsider the 14-month sentence that was assessed.
State?
Your Honor, based on what is said, I will echo defense counsel's sentiment that these items were discussed with me prior to us bringing that agreement to the court. However, I would just defer to the court's decision on this matter.
Well, what I can tell parties is that once the court enters a legal sentence, the motion for reconsideration, that's really not a legal motion. His only options, and I'm not your attorney, I'm not trying to tell your attorneys what to do. His only option is a shock probation, because the court legally cannot reconsider a legal sentence. So the motion to reconsider will be denied.
All right. Okay. Even though we're within the 30-day period, Your Honor, for plenary jurisdiction?
No.
For what it's worth, Your Honor, if I may, it was at the court's recommendation that, and the court did announce that there's not a legal means or method or vehicle to do this, but that the court would consider the new information in that format, and which is why we had filed it at the request of the
We can go off the record. My suggestion is a motion for shock probation.
Got it, understood.
Okay.
Thank you very much.
Thanks,
All
Judge.
right.
Thank you.
And now with regards to shock probation, depending on how long he's been in jail, the court will consider that.
Thank you.
All right, you're welcome.
We'll pick up the conversation.
Counsel, have you received all discovery? And did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Ms. Morales, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We did.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Counsel.
Yes, sorry.
Ms. Morales, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand your charge of possession of a controlled substance penalty group 1? 1 grams to 4 grams, that's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine.
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case? You're gonna need to speak up so the
Oh, yes, ma'am.
counsel, has your client been able to provide you with any defenses?
He has it.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I did.
Mr. Morales, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 5 years in the prison. There's $1,000 fine. The state is recommending community supervision. They're taking into consideration 2024 PF 20631. Did you understand that to be the plea?
Yes, ma'am.
Yes, Judge.
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Judge.
Outside the agreement, the state is recommending that your community supervision be for a term of 6 years. There be a TAP evaluation, 200 hours of community service restitution, the DOEP and MRT. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, Your Honor. State offers State's Exhibit 1 in all attachments.
We have no objection.
State you may be excused.
Thank you, Judge.
All right, off the record, yes. Let me see. Oh, you're in number 2. You just have to go there. Oh, let me see.
Okay, now I do.
All right, thank you. We're back on the record. Mr. Morales, did you review the waiver and stipulations with your attorney?
Yes, ma'am.
Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. Reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Judge, we just like you followed plea bargaining with state's recommendation of probation.
All right. So, sir, Mr. Morales, who is Victor Hugo Lamont Sanchez to you?
My my ex brother-in-law.
Okay. Do you have any children?
Uh, yes, teenagers.
All right. Do they live with you?
Yes, my oldest is 22.
And what do you do for a living?
I was in construction, but I got hurt, and I haven't been. They've been paying the bills right now, so but I need to go back to work.
All right. So is that workers' compensation or something else that's happening? Unemployment?
Nothing. I didn't file for nothing. I don't want to.
Okay.
I don't like taking nothing from. You know.
Well, so just as a side note, people see that as taking, but if you're hurt on your job,
Yeah. But
somebody's supposed to pay for that. Too many times people have this idea, oh, I'm hurt on the job, then I'm just going to let it slide. When if you let that slide, who knows, maybe there's something wrong with safety standards there. And if you just let it slide, then the lack of safety standards will continue.
But it's a lot of it's a lot of paperwork. It's a lot of they ask this, that, this, you know.
All right, this is what the court will do. The court is going to sentence you to 5 years in the prison, suspended and probated for 6 years. If you're drug tested today, what will happen?
I'll probably come out there.
All right, how often are you using?
Maybe like every 2 weeks or so, but
And what are you using?
cocaine and alcohol.
All right. There's going to be regular reporting by Zoom or in person. Regular random UAs. I want a referral to felony drug court. A TAP evaluation out of custody. If he's not accepted into felony drug court, then follow the recommendations of TAP. Take in consideration 2024 PF 20631. There's $1,000 fine that will be probated. Proof of employment within 45 days. No employment as a home health care provider or with minors. No unsupervised contact with minors. No contact with Victor Hugo Lamont Sanchez. Field visits 1 time per month for 6 months. 200 hours of community service restitution. I'm going to order parenting classes. Once that's completed, the community service hours will be deemed satisfied. And there's going to be 30 sober meetings in 30 days. Probation, is there anything else?
Okay.
Is there anything else you need from the court to be successful?
What's the parenting classes?
Oh, that's where you learn how to parent, right? And sometimes people will say, well, I know how to parent.
But I have no kids. It doesn't matter. They're small. They're not
Yeah, you
small.
said they were
Yeah, there's
teenagers.
22 and 20,
So let me just
24,
tell you,
26.
usually when people have children in this court, I do parenting classes.
Yes,
You know
ma'am.
why I do that?
Yes, ma'am.
Because sometimes people don't understand that your drug addiction,
Yes.
you're picking up these charges impact the children.
Yes, ma'am.
They just think, well, I didn't use it in front of them, so it's all fine.
Yes.
But all of our actions as an adult impacts our children.
Yes, ma'am.
And so parenting classes are going to teach you that. I always tell people, maintain your sobriety for yourself, but if you're at that stage where you can't do it for yourself, then maybe having that parenting class will make you do it for your children.
Yes, ma'am.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. In this court, communication is key to be successful on probation. If there's an issue, let probation know about it.
Okay.
If you feel they're not addressing it, you can always come back to me.
Okay.
If you feel you're going to use, call probation. I know some courts, people say you can't do that. But in this court, if you call probation and say you're thinking about using, you know what's going to end up happening? I'm going to set a compliance hearing. We're going to come in. We're going to try to address that to get you some help.
That's
But
fine.
if you don't tell them you need help or you're doing things in secret,
Sure.
nobody can help you.
Yes, ma'am.
All right, good luck to you, okay? And thank you for dressing appropriately for court. Thanks, counsel. I love your pen today.
Judge, I work for you.